Class today on rules that can be problematic. If there's any delay, it's my fault. I clicked the wrong button, and so the IT guy had to come running down and deal with my clicking the wrong button and then letting you back in. So sorry for any delay. You should see in the middle of your screen the PowerPoint presentation, and that should take up most of your screen. And then there should be a small box on the bottom right-hand side with my face. On the left side, you're going to see a menu that has questions and answers. So if you have any questions as we're going along, please go ahead and type those in. The CMCA credits will be generated by the webinar host, and that happens after we get a list of site attendance, and then we'll send out the credits within about 48 hours after the webinar. The credits aren't transferable, so it's only to the people who are watching the class. If you have any other questions or concerns, if you're having problems seeing, hearing, whatever the case may be, you can call Sean Sanders at our office, 303-991-2076, or you can email education@altitude.law, and Sean will try and help you get through that, and he'll be the ones who will be getting out the CMCA credits. Okay, so our topic today is rules that are problematic. We're going to try and touch base on some of the things that we see that your board members are trying to implement that do and don't work. And, you know, I found this meme online, and it just seemed to so match the issue, which is, you know, sometimes we get questions from our board members or questions from our homeowners that they want us to adopt a rule that makes absolutely no sense. And that's part of the reasons that we're going to find some of these rules to be so problematic. Okay, so what are the ground rules for adopting a good rule, right? If your community is not a Kiowa based community, your governing documents have to give you that authority. If you are a Kiowa based community, then Kiowa gives you the authority to adopt rules. Understand, your board members can't look at that authority to adopt rules as the authority to go online or to type up any rule they want to have, okay? You can clarify something that's in your declaration, and sometimes your declaration will set forth may adopt rules about parking. And so you're not clarifying, you're adopting the rules about parking that's set up. But your rules can't conflict with the declaration, can't override it, can't even be more lenient than it. If there is a difference between the declaration and your rule, the declaration trumps. Same with articles and bylaws. You cannot draft rules that conflict with those two. The other issue that comes up often is maybe your declaration is absolutely silent to something, right? It doesn't even talk about whether or not you can implement a parking rule. If you implement a parking rule when your documents are completely silent about parking, there is a possibility that your homeowners can challenge that rule as being a new restriction and stating that you're trying to circumvent amending the declaration by doing it by rule. Not always, and it's dependent upon your governing documents, but you always want to be careful about drafting something when your documents don't speak to it at all. When you get in front of the courts, you need to remember that your rules have to be reasonable. That's an evaluation that the court is going to do. It is unique, but your declaration doesn't have to be reasonable. It's a contract, it was adopted, it's in place, and so even if the court thought a declaration provision was unreasonable, it would still be enforceable. The same is not true with a rule. A rule must be reasonable, and that we'll talk about in bits and pieces. Sometimes that has to do with whether it's enforceable, sometimes that has to do with the dollar amount of a fine that is attached to it, but overall your rule must be reasonable. In addition to being reasonable, it has to further a purpose or a goal of your association. So if you are drafting rules and your community is, say, a condo community, you're furthering the purposes when you're drafting a rule that says quiet time is after 10 p.m. That's fine. That's furthering the goal of the community, which is keeping good harmony in your community. But if you're drafting a rule that says nobody can drive a pink car got no connection to your community. It's got no connection to the purpose of your community, and it would not be upheld in court at all. Obviously, you can't conflict with state and federal laws, and if you do, it's not enforceable because state and federal laws always trump. So when you go in front of court and you've got the issue with a homeowner who has failed to comply, the first thing the court's going to do is look to authority. Do your governing documents give you that authority, or in fact, does the Kiowa control your community, and thus Kiowa provided that authority? The next thing is, obviously, are there any contradictions? Does the rule further the purpose of the association? And then we start getting into kind of the really fine tuning. Is the rule clear? Think about it this way. If you have a rule, and this is something we frequently see in the Declaration and why we need to have rules, what if your rule said owners can have a reasonable number of pets? How many is reasonable? Well, one homeowner might think 4 or 5 is reasonable because they love pets and they want to have a bunch of them around them at all times. Their neighbor that lives downstairs below them that gets to listen to 4 or 5 pets jumping on and off the couch all day probably doesn't agree that 4 or 5 is reasonable and may not even think 1 is reasonable. So you have to make sure your rule that you're crafting and you're helping your board craft is a clear rule that everybody is on the same page. And so using terms like a reasonable number of pets is never going to be considered a clear rule. You need to say that the board has determined that a reasonable number of pets is allowed, and that reasonable number is 2 or 4 or whatever the case may be, but it needs to clearly state what the limitation is in the rule. Is it reasonable? Reasonable goes to a lot of times fines, right? Let's look at this. If you have a community that says you can have parking only in certain places, and those certain places happen to be in the streets or in the driveways, and you can establish that the reason for that is maybe you have really narrow streets, right? There's a real good purpose behind your rules in limiting the parking to certain areas. But if in fact you have really super wide streets, they're boulevards, there's parking marked on the streets, and you try and craft a rule that says no parking in the streets, the court's going to come back to you and go, that's not reasonable. What's the basis for the rule? If you can't establish and connect to the reason for the rule and why you need to have it, there's a good chance the board will strike it. Fines often fall under the reasonability issue. And that issue comes up with situations such as, let's say your standard rule, must put your trash cans away when it's not trash pickup day. If your violation and your fine amount for that rule is $1,000 every time they don't put the trash can away, it's probably going to get struck by the court. Okay? That's not going to be determined to have a valid purpose and reasonable standard. Now, if it's $10 a day every day it's out, while that fine might reach $300 if it's out 30 days of the month, it's much more reasonable, right? $10 a day. So if you walk your self down and move that trash can right back up to where it belongs to be, then it might only be $10 or it might be $20, but it's not. The connection to the fine amount has to do with the lack of the action on the part of the owner or the tenant, not to whether or not the fine is reasonable. Okay, another thing you always have to look to is, can the rule be fairly enforced? A really easy example of this one is parking. Parking. A lot of times you're restricting parking, right? Don't create a rule that says you can only park in a certain spot for 2 hours, because it's never going to be fairly enforced. Some homeowners might be home sitting at their window all day and watching outside and watching parking, and they can say, well, such and such parked in front of my house for 4 hours, and this other person parked in front of my house for 6 hours, and nobody else is home all day, so nobody else is getting the enforcement because nobody else is there to monitor a 2-hour window. If you don't have somebody who's going to go out and chalk tires and measure the time somebody's there, don't implement a rule that puts a time restriction on it, because it's not going to be fairly enforced. I have a question that covenants restrict holiday lights after 30 days after the holiday. Homeowners left the lights on the home and put up a lighted cross on the side yard. Covenants do not state what holiday, and so they're claiming that the lights change every month. Well, again, you got to be really careful about that, because if you start restricting Christmas lights, then you might run afoul of some religious accommodation requirements. So if you label your holidays with which holiday it is, you could run afoul of some other problems. If you don't label it, you probably have Christmas, and then I'm sure there's Martin Luther King Day in January and President's Day in February. I'm sure that they can come up with one pretty much often as they like, and you're probably going to get stuck with them. There's not tons of things that you can do to restrict it, and the only way you're going to do so is putting some restrictions of no lights up for longer than X. Don't call it a holiday lights, just say no lights. If you don't want them, and then do it that way. So let's go through some examples, because I think that's the easiest way to look at this. In the example above, you assume that the association wants to stop parking, right? And they want to stop parking in the street. So whenever you're talking about parking in the streets, you're going to have some concerns about, do you own the streets? Do you control the streets? Now, there are many, many times that associations do not own the streets, but still have authority over the streets. That is completely dependent upon your governing documents, when your declaration was recorded, when the streets were dedicated to the city or the county. There is no hard and fast state law currently, or maybe shortly, but there is currently no hard and fast rule on parking in the streets. And so parking in the streets takes a review of your documents to determine if you can do it. We frequently have board members who say, it's okay, I talked to the cops and this is who has authority. While I am a big supporter of the police, because I was a district attorney and worked with them for many years, they don't know civil law. Do not call them to get clarification on what your covenants can or cannot do. And if your board is calling them to get information about your covenants, you're probably got a bad source. Going back to the light rule, the question is, if the light rules are in our governing documents, is it okay? I don't know. I don't know if the light rule, what you're mentioning, so I can't tell you if it's okay. If you're trying to change holiday out of the covenants, that's a vote of all homeowners. And yeah, you'd have to do the full amendment to get rid of that. Okay, what about if you're talking about no overnight parking? Assuming that you have the authority to take care of the streets and you want to say no overnight parking in the streets, can you do that? You have to be really careful with those kinds of questions, because what's overnight? Does it mean that any car that's there once the sun goes down? Is that what you're going to determine to be night? Are you going to define night? Does it mean if they're there for 5 minutes during the nighttime, it's a violation? Does it mean if they're there all night during the night, it's a violation? I understand this type of rule is something that a lot of communities implement, but it takes a lot of detail to make a rule such as this enforceable, simply because it's not clear. Whenever I see this rule and they try and enforce it in court, there's tons and tons of pushback by the homeowners claiming, I don't know when overnight was, or I just stopped by for 5 minutes. It just happened to be during the period of time that somebody was doing inspections. And there's often challenges because how many managers really are driving through a community at 10 o'clock at night to find out who's parking overnight? And so a lot of times you don't have fair enforceable rule because it's the only people, you might have one part or one street in your community where the people, are up all night because, they have a little baby. And so they get to get up and down all night, and they call in all the violations, and no other part of your community is calling it in, and nobody else is doing inspections. And so you could have a challenge to unfairly enforcing. And so you could have a challenge that it's not a reasonable rule for that reason. Question, if the association is pre-Kiowa and the documents read they can enforce rules over public street parking, can this be done? So the issue about street parking isn't about whether they're Kiowa and isn't about whether the documents say that you can enforce parking. You have to have clear authority over the streets before the streets are given to the city. And if that authority in the declaration isn't clearly in place before the streets are given to the city, you don't have authority to enforce on the streets. So I've had many a community that had very clearly absent parking in the streets, and they don't have any authority in the streets. So it's very confusing for their homeowners. It's very frustrating for people. They call the manager all the time and complain about the parking in the street, and the association knows they have no authority to take action. And so they're in a horrible position. So just because it's in the covenants doesn't mean you're going to have authority to take action on it. Another question, what if the road is private and the board is prohibiting parking in front of people's home and labeling it a fire lane, yet there's no marking for an emergency lane? Well, if the board owns the street, meaning it's a private street and the board owns it, they can set up all kinds of rules, just like they set up rules for the pool, like they set up rules for the clubhouse, because they own it, they can control it, and they can draft rules about how it's used. The distinction between making it a fire lane or not generally takes help from a fire marshal. The benefit of having it truly be a fire lane as defined by the fire marshal is you, the association, don't have to have the cars towed. You can call the cops. So if you have a fire marshal come and mark it and designate it as a fire lane, then anybody can call and have the cars towed anytime there's a car parked in violation of the fire lane. But if it's a private road, certainly the board can mark it no parking, and they can call and have cars towed for violating the private road because they own it. What about parking RVs, right? This comes to be a bad rule because what we frequently see is the documents might say no RVs are allowed in the community. And so what happens is the HOA starts enforcing that, and owners start complaining to the manager, I need time to load and unload. I mean, come on, it's only going to be there a little bit. And so then the board says, well, can we draft a rule that says they can be parked there for loading and unloading? The answer is it depends on the covenants. If your covenant says no RVs in the community, then technically, no, they can't even be there to load and unload. They need to take it to storage, and while it's at storage, unload everything into their car and bring it back home. You cannot create a rule even though it makes no sense. I get it. If people want to have RVs and they want to load and unload in front of their home, you want to create, we're going to create a rule that says it can be there only during loading and unloading. But the problem is that if the declaration says none, you've just contradicted the declaration and it's no longer a valid rule. If your declaration says RVs can be parked in the community only during loading and unloading, can you draft a rule that says loading and unloading can only last 24 hours or 32 hours or 48 hours? You're going to be very close to crossing the line, right? The problem with that rule primarily, and the reason that doesn't work most of the time, is if you give homeowners 48 hours, say, before and after each trip, that means your RV can show up on Wednesday for the Friday leave, and it can stay till Tuesday after it comes back, which means that there's only one day of the week that it can't be there. And that is not what the documents mean if the document says no RVs in the community, and you will have a homeowner who will complain and challenge you that you've drafted a rule and you're trying to contradict the declaration by rule. The better response is if your document allows for loading and unloading, is craft a rule that says loading and unloading means active activity, right? They're actively walking in and out and in and out and in and out to unload or to load. And if it's not actively happening, it's a violation. That puts some, restrictions on people to very quickly load and unload. And that's about all you ever want to go with, because again, when you start tinkering and trying to clarify the rules for whatever reason, you are going to annoy somebody who moved into the community and who's going to claim, I moved to this community because the community had a no RV rule and I hate them and I think they're horrible looking and they detract from my house and I don't want them there. And so you're creating a rule and allowing it to happen is violating my rights as a homeowner because I bought into the community because it had no RVs. And that's the challenge you're going to get. And then they start telling you how you're costing them money because you've decreased the value of their home by allowing this. So again, you want to be very careful trying to create a rule, even if you're trying to be nice and helpful to your homeowners. Be careful on your fines for parking RVs. I bring this up because I've had communities that the fines for parking the RV, even if they were a daily fine, were less than the monthly cost to store an RV. And when that happens, it's cheaper to pay the fine than move the RV. And so the fine is not doing its job. Make sure your fines are of a suitable amount to make it a penalty. So call the local storage facility near you, wherever that may be. Ask them what it costs to store the RV for a month at a time, and make sure that your fines are going to be more than the storage costs to store the RV offsite. Make sure that your rules are not something that is going to end up being in a cartoon. Don't have rules about the height of your grass and the amount of down to the inch or down to the anything that hyper critical. One, how are you going to enforce it? Are you really going to go out there and measure something that fine? Nobody's going to have time for that. If you're going to create rules, make sure that there's something that you can enforce in a drive-by. As you're driving by the house, and you can say, your yard cannot be completely rock. It has to be half living material. If you can't drive by that house and have a pretty good idea whether or not they've met the half requirement, you might want to change your rules. Don't make it something that you really can't tell. Okay, what about satellite dishes? Satellite dishes obviously are covered by the OTARD rule, OTARD, over-the-air radio devices. And they do not cover something this large. They cover a 3-meter dish. That photo is not a 3-meter dish, and so that obviously wouldn't fall under the OTARD. But beyond that, huge amount, many board members want to put restrictions on where satellite dishes can go. And there are very little changes you can make when it comes to where a satellite dish can go and still stay in compliance with the FCC OTARD rule. If it's a single family property, there's not many rules at all that are enforced, aren't going to run afoul of the federal rule. You can put suggestions in your rules, and it's the only time I'm ever going to tell you to say suggested, because suggested isn't enforceable. We suggest you do X. Okay, it's not enforceable in court. But you're never really going to want to take a satellite dish to court, because again, OTARD is what controls. Now, if you're a single family home, you can certainly say we prefer if you put the satellite dish on the south side or on the back side or whatever the case may be. And so long as they can get signal in that portion, it's okay to make that suggestion. It's not enforceable, again, OTARD says pretty much if it's a single family home, they get to put it wherever they want. Now, if you're a condo, you can have rules about the satellite dishes because condominiums, the HOA owns the walls, they own everything except the exclusive use area of the patio. And so you can have rules in condo saying you can't attach the satellite to the wall, you cannot attach the satellite to the railing. You cannot have a rule saying you cannot have a satellite dish on the patio because, again, OTARD says that if they put it in on a pole on their patio, that's an exclusive use area of theirs, they get to have it. So you have to be very careful on satellite dish, any kind of rules about them, because you can run afoul of the FCC pretty quickly. I have a question that a board wants to call the county sheriff for regulations regarding the street that is because they're trying to enforce no parking. Well, yes, it's recommended if there is a county ordinance that says no parking in the street, you can call the county sheriff to enforce that county ordinance. You can't call the sheriff to try and enforce an HOA rule because county sheriff has nothing to do with the HOA rule. So it's only if there are county ordinances or state law that you think is being violated, then yeah, absolutely tell your board to call the sheriff every time there's a violation, because it's always better to have the sheriff enforce than making you guys enforce. Oh, it's reception device. See, I even said the rule wrong. It's over-the-air reception device. So again, you want to take a look at this. You want to make sure that you're never going to impair installation, and you can't delay it either. You have to be really careful, and that's why sometimes in a rule giving your preferences in advance helps you, because if you delay things by making homeowners submit first and then wait for you to approve it, you could delay their installation, and that will cause you to be in violation of OTARD. Okay, pool rules. Pool rules are one that you have to be very careful with, right? Why? Because so many pool rules are really about children running around the pool area and children getting hurt. And the reason that these issues often come into question is the Fair Housing Act. The Fair Housing Act prohibits discrimination of familial units, right? And so in some communities, there was a desire by the community not to have kids. They didn't want to have kids. They wanted to have an all-adult community. And so the way they tried to do that is create rules that made it very difficult for families to live in the community. And so the Fair Housing Act says, yep, that's got to stop. That's discrimination and we won't allow it. So now, because of that Fair Housing Act, boards just trying to, have a safe pool area and not have children hurt, really have to be very careful how they do things and what they do so that they don't run afoul of the Fair Housing Act. So one of the issues that you're going to run into is, while it might sound like it's common sense, many times you have to reword your proposed rules so that you cannot be accused of violating the Fair Housing Act. So instead of children must wear swim diapers in the pool, you want to have a rule that says anyone who has any concerns about incontinence needs to wear swim diapers in the pool, because some of your senior citizens probably have the same issue as some of the babies. So that you're addressing the rule to address the problem, not pointing at who it might be who is having the problem, right? So take the word children out and say anyone who needs it must wear swim diapers. Children must have adult supervision. This one is challenged frequently. And again, what we can show in court is that if we can show in court that the rules in place only for safety, then it'll be upheld in court. So again, it's not all children, because probably the 17-year-old who's legally a child doesn't need supervision in the pool. If he's not with, and I say he because my husband assures me that men's brain cells decrease in direct proportion to the number of men together at the same time. And I think he's correct. And the same with boys. The more young boys you have running around, the less likely any of their brain cells will work. I'm sure girls are in there too, but I like picking on the boys. Just, you know. So one of the things you want to do is attach enough explanation to your rule to show it is for safety only. So what we normally see is children under the age of 14 must have adult supervision. Sometimes I have seen boards say must have adult supervision or prove they're proficient swimmers. I don't generally recommend proficient swimmers as a comment, simply because what I've seen over the years, and anybody who's got kids, I think can understand this, most of the time the danger to the kids isn't solely in the water. Kids are kids. They run around, and the pool area outside the pool is slick. And if you don't have an adult there who says, stop running, you're going to slide and hit your head and fall in the pool and drown. That's what we want to stop. So it's not just about being a proficient swimmer. It's about kids are kids, and we want to make sure they're going to be safe. And so I recommend generally children under 14 must have adult supervision. Swimmers are also an issue that we have seen raised. This is an area where you have to be very careful what you're requiring, simply because we've seen this come up as religious discrimination. So you have to allow people to comply with their religion. You don't have to accommodate. You simply have to not discriminate. That's how the rule works when it has to do with religion. And so you want to place it as only swimwear is allowed in the pool without trying to get into too many specifics. Because if you get into too many specifics, you're going to run afoul of some religious requirements. And so it's always good to kind of work with your attorney to make sure that how you're defining things and what you're putting in there is not going to run afoul of anybody's religious requirements for swimming. Adult only times is not ever going to be allowed. That is going to be considered familial discrimination. So if you have areas on your pool where people like to swim laps, or you want to have lap only hours during the day, you can certainly do that. But you define it specifically as, between 6 and 7 every morning, lap time only, meaning they can swim back and forth in laps, but there's no kids jumping around playing because obviously it's hard to swim laps if there's kids in the way. But you can only do it by defining it as a lap. That's the hours that it will be allowed for a lap swimming only. Okay, proof issues become one of the big things that restrict your rules and make them unenforceable. There are a lot of things that boards try and help and deal with that are very difficult to prove in court. And you have to keep in mind that there are rules that are with the best intention, but they may never be enforceable. There are some easy ones that we all kind of think about, but the biggest one is, and oftentimes this isn't just a rule. Sometimes this is in your covenants. No offensive activity. Well, offensive to who? Offensive how? It becomes very difficult, and you're pitting one person against another. And because 90% of the time, nuisance provisions are one neighbor against another neighbor. And so your neighbors are basically saying, one neighbor says whatever it is that's being done is horribly offensive, and the other neighbor goes, no, it's not. And so you got one against one. If you're the plaintiff in court, you have to hit 51%. And if you have one witness who says it's offensive and they have themselves and they say it's not, you've just lost because you didn't meet your burden. So anytime you're looking at a situation where the issue is not really well defined, it just says offensive conduct, make sure you have at least 2 and preferably 3 witnesses before you go to court. Because if you have 3 people saying whatever it is the neighbor's doing it, he's doing it to a degree, it's offensive to 3 different people, you probably got a solid case in court. If you don't have the 3 witnesses, you're probably not going to prevail in court. Odor comes up a lot. One of the things that you often have is when it comes up for odor is smoking, marijuana. Those are huge issues. Lots of boards want to restrict it. Lots of boards get complaints about it, want to try and help their neighbor, and are really in a bind because neither of those things is illegal. So just because one person finds that smell to be offensive, it's illegal conduct that's happening inside a unit. So those kinds of issues are exceptionally difficult to try and follow through, fine, or take to court. Again, you can always try the get 3 witnesses who say, look, they smoke so much, it is offensive to all of us because the hallways reek and it's coming through the patio, or my son's asthmatic and he can't breathe because of it. It becomes very, very difficult to deal with odor because of that. The other thing you need to remember when we're talking odor is the most common time we see this is condos or townhomes. It's obviously a lot less of an issue when you have single family homes, although I've seen the complaints where single family, one neighbor's complaining about the other neighbor outside smoking and the smoke drifts over and bothers them. So it's not solely the condos and townhomes, but it's certainly those two that have primary issues in this. You need to be careful about that. One of the things that we run into is when you have one homeowner who says, you need to stop my neighbor from smoking because it drifts towards me and it's bothering me. Many times the way that the smoke is traveling through the condo is through the common elements that are owned by the HOA. So if you have a board member who's decided he's going to fix this and he's going to help, he needs to start seeing the dollar signs, because to try and stop the air traveling between one condo and another may be excessively expensive to seal off the units so that the air does not travel between one and the other. Okay, so be careful what you promise. More than likely, the most effective way to stop smoking problems is to create a covenant that says no smoking building. Doesn't matter what you're smoking. Doesn't matter if it's marijuana. Doesn't matter if it's cigarettes. It's all prohibited. That will address it. And because marijuana is still considered illegal federally, they can't raise the FHA and say, no, I still get to have my marijuana because it's a medical issue and I'm disabled without it, and so you can't stop me. The other thing is, under the Colorado Fair housing rights, even if they said, well, I'm disabled and the Colorado Fair housing rights would allow me still to have marijuana because I'm disabled, you could say, no, you could use an edible. And since they're so easily available in Colorado, you can still get the same benefit from an edible, and you can't smoke because no smoking is allowed. And so again, in that circumstance, you could argue that it would not be a reasonable accommodation when there are other avenues for them to still get the same medicine. And so you could do it that way. But that takes a covenant amendment. And that's the only really strong way to stop smoking. You can always try nuisance, but it's going to be hit or miss. It really is. The cases that have gone through the courts have not been very successful stopping smoking when it's a legal activity and they're within their own home. Excessive noise is also very difficult, because what's excessive, that's when rules will really help you. Setting forth quiet time hours, because then anything after 10 p.m. you can deem excessive, right? Because that's quiet hours. And so if you have a guy who's always playing in stereo and he always says, I don't have it up that loud, and the neighbor can go, it's exceptionally loud and I can't sleep and my kids can't sleep. If you've set the time limit at quiet hours at 10 o'clock, you've helped yourself kind of overcome what is or what isn't excessive. Question was, what about pictures, videos, recordings? Videos and recordings are awesome for obviously noise. And maybe for offensive activity, depending on what the person's doing. But obviously they can't help you with odor. But yeah, convincing, I have a pending case right now where I have the complaining party who is recording every time the neighbor turns up the stereo, and we can hear the bass, going boom, boom, boom. So it's really helpful. Is an amendment stating no smoking in a building applicable to owned condo units as well as a rental unit? If you do an amendment, it's everywhere. I mean, if the amendment says no smoking, it's no smoking. So if you amend the covenant, you can restrict it to every unit. Okay, what about security cameras? and rules about security cameras. So there's a lot of different issues going on when you start talking about cameras. Everybody presumes and everybody thinks that nobody can record them, take pictures of them. I frequently get complaints from people saying, my neighbor took pictures and my children were in the yard and I'm going to sue. I don't really care that your children were in the yard. People can drive by and take a picture, and if your kids are in the yard, so what? Kids are in the yard. There's nothing illegal if the person taking the picture was in a spot they were legally entitled to be. You're walking down the sidewalk, you can take all the pictures of anything you can see. You're legally entitled to be on the sidewalk, take all the pictures you want. So what happens when it's a security camera attached to a house? Does that change anything? So most of the time, the camera issue is about, is there an expectation of privacy? And there generally is very little expectation of privacy on your front porch, right? You expect people to knock on your door, deliver your pizza, deliver your mail, deliver Federal Express, whatever the case may be. So there's not a lot of expectation of privacy. And so the Ring cameras and the fact they're recording people who walk up on your porch, there's really no expectation of privacy. So then the issue becomes, why would you need a rule about it? Some communities have extremely strict requirements about any alteration of any kind must be pre-approved. And that's fine if you have that rule. And if you do so, I would recommend placing in your guidelines that security cameras are allowed so long as they are, any wires to them are painted to match the building, and they're small, they're unobtrusive. Put a size requirement on it. Those are appropriate rules because, again, as an association, the only concerns for an ARC is that it not detract from your property. And so long as, most cameras now are small, they're 3-4 inches. They're not these large, ginormous things. It's not going to be anything that's going to affect your property values. And so if you're going to have an ARC rule about it, you want to limit your rule to being that which will have an effect, right? Remember, purpose of the community. The purpose of your community is to maintain property values. So how is a camera going to affect property values? It's not. So keep your rules to connect to the purpose of the community. And when you're looking at that, some communities take a step forward and go, security cameras are allowed so long as they are this small. And then you don't even have to apply for it. Anytime the issue is about security, as an association, if you start telling them no, you're creating some liability. Because if they say, I want to put up a camera, and the board goes, well, we don't think any camera should be allowed, and then they're burglarized, they're going to sue you and say, if my camera had been up, it would have been a deterrent and you prevented it, and therefore you're responsible for all my loss because I was burglarized. So you want to be really careful when you're stopping a homeowner from doing something that is a security conscious thing, okay? So we don't generally recommend prohibiting security cameras. We just put some small limitations on them. So I have a whole bunch of questions on this topic. Should an HOA board allow HOA members to install them? I see no reason why homeowners shouldn't be allowed to install security cameras. They want a security camera. Again, most of these things are small and it's not going to be a problem. Obviously, if you have a condo or a townhome and it's going to be a penetration into a wall that the HOA maintains or owns, you absolutely want to have some restrictions in place that says it must be professionally done, or the owner is going to be responsible for any penetrations into the wall to make sure there's no leaking and no damage to the wall. Those kinds of rules are going to be supported by your documents because you're either in charge of maintenance or you're in charge of, you own the wall itself. And so those are fine, but otherwise you want to let them do it. What if a camera is directed towards someone's garage? So, doesn't matter. Again, if my camera is attached to my house and it's pointed out, anything I could see with my eye, I can take photos of. So there is no violation there. What if the community members are asking the board to install security cameras in the HOA controlled parking lot? Awesome question, because it lets me explain a risk to the HOA, which is anytime the HOA is the person putting up a camera, you want to make sure you're telling homeowners those cameras are not monitored. Okay, that is critical. We had a case in Denver. HOA put some cameras up in the parking garage because they were having vandalism and they wanted to have something to turn over to the police. Homeowner then unfortunately got mugged in the parking lot, and she sued the HOA and said, I relied upon you monitoring these cameras for my safety, and you weren't monitoring them, and I was mugged, and that's your fault. And she sued them. You want to take away that ability to claim reliance upon you monitoring cameras. And so if you are going to put up cameras, that's great, but you want to put signs with them that says these are not monitored, okay? So that they know that they'll be turned over to the police later, but they're not being watched, so that they can't be a claim that in fact somebody relied upon you to protect them. How about front door locks that have keys or keypad combinations to unlock? Can these be prohibited? Why? I don't understand that question. You're going to have to give me more details. I can't answer that one. Can an HOA not allow a camera to be connected to a common element, i.e. the exterior wall? I don't recommend it. I don't recommend putting that prohibition up. I don't recommend prohibiting a camera, because a camera is about security. And when you refuse it, that homeowner, heaven forbid, if they're injured, they're going to sue the HOA. The better process is to say, we will allow you to do it if it's professionally done, and you guarantee any damage they'll fix, they'll maintain, they'll repair. That's the better approach. If signs are up stating that cameras are not monitored, won't that backfire if a crime is committed, because criminals can then read the sign and know they might get away with it? Your job is not to stop crime. If you think a crime is being committed, call a cop, because that's not your job. And so while the cameras are there because we're going to turn the camera footage over to the police after the fact, yep, the criminals are going to walk away with whatever they took. And then we're going to turn all the photos and videos over to the police, and they can hunt down the persons or not. But again, not the HOA job to stop a crime, ever. Can the HOA point the camera into the shared hot tub? Yes, because there is no expectation of privacy in a public area, or it's public to your members. And so it's an area of no expectation of privacy. So yes, you could have the camera pointed at the pool, pointed at the hot tubs. Can owners use audio video cameras such as Ring doorbell? Okay, very good question. So the issue with Ring doorbells are that they not only record sound or record photo, they record sound. And in Colorado, there is a law that says you cannot record someone if you're not present. Meaning you can't set up a recorder in your office and walk out of the room and record secretly whatever conversation is being had by whoever you've left in your office. That would be illegal. That would be a violation of the law in Colorado. So there is that issue, and there is that concern with Ring. It has not come up that I have seen as far as a court case, and I do not know what the courts would do with it. If you're standing on somebody's front porch, I don't know that you would have a valid claim of an expectation of privacy. And Ring doorbells, clearly, everybody knows they record sound and photos. So it's unclear to me what the courts would do. Generally, if you're going to allow them, and I think you should, because I think it is a security issue, my recommendation is in your rules, you comment that you're not taking any position, and you don't know if they're legal in Colorado, and you don't know if the fact that they record sound will be upheld in Colorado, and that's not something that you're opining on. You're simply approving the doorbell with the camera because the homeowner has a right to have a security camera. Can an association allow a camera in a common area such as a shared garage, large gathering room? Yes, an association can have a camera in their common areas. No expectation of privacy. there's awesome photos that come off the Ring doorbell. So it's always interesting to see what walks up to your front door. Okay, what about other restrictions? And this comes up when you start talking about prohibiting items, say in the common, like a common hallway in a condo unit. You might have a hallway and condos on both sides. A lot of communities have rules that you can't put anything up on the walls of your community, because those are obviously owned by the association. They're common walls. But you have to be careful about that. If an owner requests to place a small religious symbol on the door, you have to allow it, because your job is not to, you don't have to accommodate a religion, but you also can't discriminate against them. And clearly, if an owner wants to put something that small on the frame of their door, and by the way, I enlarged that item that you're looking at is less than 2 inches. So I just blew it up so you can all see what it looks like. Again, you want to be respectful of people's religion, and try not to infringe upon it. And that's something, again, while you want to prohibit large items, if you're allowing a Ring doorbell on your walls of the hallway up and down the condo, if somebody wants to then place an item this small, you would have to allow it, because you're allowing the doorbell. So kind of remember that, as you're looking at one rule, what, one owner wants to do, another owner might want to do something similar, and you cannot have selective enforcement. Dog rules. Dog rules raise all kinds of issues in enforceability for all different kinds of areas. And you have to be careful that your rules are clear when we start talking about dogs, because one of the things is owners want to do what they want to do, and they are going to fight you every step of the way. Meaning, I've had many, many times that a HOA wanted to have a rule about dogs must be on a leash. And so what we saw is owners attach the leash and never hold it, and the dog drags it along and still is off leash, running around and roaming, and the dog goes, and the owner says, "Hi, I'm in compliance, the dog's on a leash." So you have to be really clear and almost to the point of stupidity. Dogs must be on a leash, held in the hand of an owner. We generally recommend a distance, actually, because you now see those leashes that are 20, 30 feet, and you really don't want the dog 20, 30 feet from somebody. So putting a distance of the leash is a good idea too. Being held in the hand of a responsible individual is a good idea. But be very, very clear in your rules, because the more clarity, the easier it is to enforce against somebody who's looking for a loophole. Okay, so the keypad door lock question was a situation where the HOA said all door locks had to be the same, but they allowed for extra deadbolts. Can the HOA say a keypad door lock is not allowed? I think you could, but I would expect almost immediately some pushback from one owner or another saying that their child needed to be allowed to access their home, and the keypad door lock was the only way they could do it, because their school uniform didn't have any pockets, so there was no way they could have a key. I mean, I'm sure that the homeowners are going to come up with something and some reason to say they must have a keypad door lock because of something. So I would imagine you're going to get pushback pretty quickly on that. I don't know that I would have a hard time seeing a distinction between a keypad door lock versus a regular door lock having a distinction in property values. Remember, purpose of a rule has to be to further the purpose of the association. Purpose of the association is to have property values remain high, right? So how do you connect those two? Obviously, we frequently have the complaints coming in on the dogs because there's not dog poop being picked up, and who knows which dog did it and who the dog belongs with, right? Proof problems. If you can't prove it, you can't enforce it. Pictures, as somebody said a minute ago, should we take videos? Should we have cameras, pictures? They tell, the story, and they make it so much easier to prove in court. Oftentimes we have issues because something happens so fast that we don't have times to get the rule, the rules has been violated, right? But we don't have time to get the letter and have a hearing and before it's already corrected. Holiday lights, garage sales happen one day, a couple days, maybe a couple weeks, and then the season is over and it's down. So if you don't act quickly, and if you have a requirement that says you have to have a warning notice, wait 14 days, then have a fine notice, it may be down long before you ever get things resolved. So it's not that the rules are bad or unclear, it's just you're never going to enforce them because they're going to happen so quickly. And so to make those rules enforceable, you have to make sure your covenant enforcement policy has the ability to have not that 14-day wait, that constant, wait 14 days to get things if you want to deal with issues that are short-term issues. Leasing rules often can be difficult, and the reason they're difficult is who's the tenant? Do you really know there's a tenant? The reality is a third of our nation rents. As managers, you all know we do not have that high of a number of violations in our community. So you cannot say all tenants are bad. And many tenants have been there years and are long-term tenants, and nobody even knows they're tenants because they've been there for so long. So leasing rules often are difficult to enforce fairly because we don't always know who's leasing. And so it's something to always be considered. How do you enforce lease rules when people from other neighborhoods walk in your neighborhood? I think you mean leash, like a dog leash, and that's a problem. Again, there is no way to enforce it because if your community is not a small gated community, then your streets are your streets are not private, your sidewalks are not private, and people can walk in your community, and so you're not going to be able to enforce it all the time. Yes, homeowners, HOAs can require owners to rent to give the HOA a copy of their lease if they have a rule in place that says so and they have a declaration that says so. Let me get through the last few slides pretty quick here. So sometimes you have boards who want to prohibit the use of the garage for storage. One, it's a very hard thing to prove because owners are generally, or tenants, not as accommodating as this owner and leave the garage door open so you can walk by and take a photo. You often don't know. Furthermore, you can't have this kind of a rule. It has to be in the covenants. You cannot restrict what happens inside a unit by rule. That needs to be in the covenants themselves. And so if you want to restrict something, probably what the board really is concerned about is parking. And they don't want the garage used for storage because parking's limited. So have a rule about parking. Don't try and control what's inside the unit. Try and address what is exterior because that's what the courts care about, is what's exterior. Making sure you have authority and you don't exceed your authority, okay? If you have an ACC provision and you're trying to make sure that you have community harmony, a lot of boards want to have the person who's going to build something in their backyard go ask the neighbors for permission. Okay, that's delegating the board and the ACC's authority. That job of what should be approved or shouldn't be approved is the job of the ACC. It's the job of the board to say yes or no. And telling a neighbor or a homeowner to go get their neighbor's permission, one, it's temporary. Because the minute the neighbor sells, a new neighbor is going to move in and that new person may not like what was built. And so you haven't fixed anything just because you had them go next door and talk to them. And so, again, you're trying to delegate authority to somebody else. It's the board's job. It's the ACC's job, not the neighbor's job, to have to say yes or no to a project. And plus, because it's temporary, it doesn't really hold any weight. Self-help is a rule we see frequently. Be very careful about it. It's very difficult. It's very technical. And going onto somebody's property can be very dangerous. Be aware that there may be rules created saying you have self-help. One, it's not going to be valid to go onto somebody else's property unless it's in your declaration, because it's basically an easement. You're saying the board has an easement to go onto somebody's property and clean up or correct a violation of the covenants. And so by rule, that would never be a valid rule. It would have to be in the covenants. And if it's in the covenants, it's very technical and very difficult. So you want to make sure that you talk to your attorney before taking those on. You want to make sure that what you're creating a rule about is what needs to happen, right? Having a rule that says grills must be 10 feet from the siding of a unit might be okay. But saying that residents that have a barbecue grill, any damage caused by it must be covered by an insurance policy. Are you really going to require every person who has a grill on their deck to hand you their insurance policy? You're going too far. You're making it unenforceable. Homeowners are not going to give you their insurance, and it's going to be very, very difficult. Don't add things to your plate when you already have enough. Making a rule, keep it 10 feet away, great, but don't go beyond that. You cannot have a rule for everything, guys. That's the bottom line. Who's going to think that some guy's going to put a couch on the top of his roof and sit up there and drink his beer? Nobody. You're going to have things that are going to come up that you're not going to have a rule for. Just be aware that you might have to go after some weird things just by under your nuisance provisions, because not everybody is going to think through all the different weird things that somebody may want to do. Just make sure that any rule that you're going to do is supported by your authority, and it's for a valid purpose that furthers the purposes of the community. I have a whole bunch of questions here. And so let me see if I can try and scroll back up because I got so many past me that I can't. How do you find out if a road is private, owned by the HOA, or public? It's on the plat, correct. And it also should be in the declaration as to who maintains it. And it might be spelled out in your declaration. Generally, in your declaration, it talks about all the different things that you own. And generally, if you have to maintain it, you own it. Not always, but sometimes you have to look to that. Can an HOA require installation of Ring doorbells and keypads must be professionally installed and prohibit a homeowner from performing the installation himself? No, but you can make him responsible for any damage he might make. So if an HOA says, yes, you can have a Ring doorbell, you have to make sure that it's not going to damage anything. Now, if he's cutting into something you own, right? Let's assume we're going back to the condo as an indoor hallway, and they're actually going to be cutting into the HOA wall in that hallway. Yes, then you could make him use a professional installer. But if he's outside and he's not cutting into an HOA property, all you can do is tell him that he needs to make sure that no damage is done, and any damage will be his responsibility to pay for. My board wants to control who comes and goes in the neighborhood. They want all brokers to check in with me. They really don't get that's something that can't be controlled or enforced. Janet, I'm so sorry. And I have no idea. You need to tell the board, unless they're a gated community and want to pay for a guard at the front gate to check people in, there's not much you can do with that. If the association pays for internet and wireless modem inside the unit, can the HOA regulate network names so that they're not offensive or vulgar? I don't think so. Because you could have a phone that has a hotspot on it, right? And so if I have and I could name that whatever I wanted to name it, and then use my phone as my hotspot, and then that's my wireless throughout my unit. I don't think you can do that. Guys, thank you all for coming. Sorry for the slight delay at the beginning. That was completely my fault. And if you have anything else that pops up, please give us a call, and everybody have a great day.